Hare Krishna. Welcome to Tax Guru YouTube channel. This is CA Rohanar Pingle, practicing chartered accountant based in Mumbai, also partner in Motilal and Associates LLP, member firm of Marks Network. Welcome to video series What Law Says. And today we are going to discuss case laws under direct tax reported to ITAT and High Court, Part 10. Let's dive into it. Let me allow to share my screen. What law says? Direct tax, Part 10. In first part, we will discuss case laws reported to ITAT and then reported to High Court. And at the end, we will see one-liner conclusions that can be drawn from today's learning. So stay tuned till the end. And whenever you want, you can take a note of it. Take a notes. Okay, let's start. First case. Late Nimmatoori Raja Babu versus ACIT, Hyderabad, 2025. Relevant assessment year is 2016-17 and 17-18. Date of order is 12th September 2025. Relevant section 271D. Let's understand facts and issue of the case. The assessee sold land, that is agricultural land, by registered deed dated 24th June 2016. Sale consideration admitted at approximately 33.75 lakh per acre for assessment year 2016-17. Consideration partly received in cash, and assessing officer alleged violation of section 269 SS, that is cash received beyond specified sum, and accordingly levied penalty under section 271D, that is 100% of amount received in cash. So issue was whether penalty under section 271D can be levied for cash receipt on sale of agricultural land, which in the case the assessee claimed was not a capital asset under section 2 subsection 14, despite registered sale deed, witnesses, etc. Very interesting. Let's see what tribunal observed and held. The tribunal held that the land sold was agricultural land, that is outside the ambit of capital asset under section 2 subsection 14, and thus transaction didn't attract section 269 SS, which is restricted to specified sums in respect of capital asset. Okay, section 269 SS is restricted to specified sums in respect of capital asset. If it is not covered under capital asset, then it is not applicable. So therefore, penalty which was levied under section 271D for contravention of section 269 SS was not sustainable and was deleted. The tribunal held that receipt in cash of genuine sale consideration of immovable property, including agricultural land, before witnesses at the time of registration cannot be brought within the ambit of specified sum merely because it has been received in cash. Very important to understand what tribunal held that is received in cash of genuine sale consideration of immovable property, any, because it is including agricultural land, it was saying before witnesses at the time of registration cannot be brought within the ambit of specified sum because merely because it is received in cash. So very clearly tribunal declared it. Next, Schwab Emerging Markets Equity ETF versus I2DRP Mumbai 2025. Relevant assessment year is 2022-23 and date of order 11th June 2025. Relevant section is section 70. Let's understand facts and issue of the case. The assessee is a Mauritius Incorporated Company registered in India as a foreign portfolio investor, that is FPI. It filed its return of income on 7th November 2022, declaring total income approximately 270 crores. If the assessment, if in the assessment it computed net short-term capital gains by first setting off short-term capital loss on which STT was paid, taxable under triple one A at 15% against short-term capital gains where STT was not paid, that is taxable under 115 AD at 30%. The AO in the draft under section 144C subsection were disagreed. He held that the rules provide separate columns of set off and carry forward of losses with differential tax rates, and thus the loss paid STT could only be set off against gains likewise subject to STT first. The DRP upheld the AO's view, that is the dispute resolution panel upheld the AO's view and directed computation accordingly. Final assessment under section 143 subsection 3 read with section 144C subsection 13 arrived at net short-term capital gains of 2.95 crore at 15% and 4.60 crore at 30%. So issues were whether under section 70 subsection 2 of the Income Tax Act, a short-term capital loss on which STT was paid can be set off against short-term capital gains on which STT was not paid is an issue under consideration. That is where the differential tax rate apply. That is 15% versus 30%. The rate of tax is also different. So essentially, does a section 70 subsection to permit cross offset of short-term losses against gains regardless of STT status or tax rate? Let's see. Very, very interesting. Please note down if you want. Tribunal observed and held that the court noted that section 70 subsection 2 provides that a short-term capital loss can be set off against the gain from any other capital asset. It doesn't itself impose classification according to STT paid or STT unpaid transactions. Very clearly, tribunal observed and notified that a short-term capital loss can be set off against the gain from any other capital asset. It doesn't itself impose classification according to STT paid or STT unpaid transactions. So AO's reliance on distinct columns in the rules for different tax rates was held to be not supported by the text of section 70 subsection 2. The expression similar computation in the statute refers to the computation of capital gain under section 48 to 55, not to matching STT status. Very clearly, the expression similar computation in the statute interpreted like that it refers to the computation of capital gain under section 48 to 55 and not to matching STT status. The tribunal referred to coordinating precedents of the tribunal and high court favoring the taxpayers on identical issues. Example, ITA number 4589 Mumbai 2023, Emerging Markets Index Non-Lendable Fund, and ITA number 4656 Mumbai 2023 in Vanguard Total International Stock Index Fund and case of CIT versus Rungamanti Trexmin Private Limited. The tribunal held that the methodology adopted by the SEC must be accepted. The short-term loss on STT paid transaction may set off against the short-term gains on STT unpaid transactions under section 70 subsection 2. The appeal was allowed. Next, Tejas Ghanshyambhai Patel versus ITO Ahmedabad 2025. Relevant assessment year is 2016-17. Date of order 4th June 2025. And relevant section is section 271 subsection 1 clause C. Let's understand facts and issue of the case. The assessee individual proprietor of Mrs. Mehan Infrastructure sold an immovable property as a co-owner. Sold an immovable property as a co-owner. His share 30% of approximately comes to 1.8 crore. He claimed deduction under section 54 EC rupees 50 lakhs and section 54F to the extent of rupees 36 lakhs. The AO denied these deductions because the return of income was filed belatedly and a revised return was also belated. Very interesting. AO made addition of approximately rupees 86 lakhs by disallowing the deductions and levied penalty under section 271 subsection 1 clause C for furnishing inaccurate particulars of income. The penalty amount approximately comes to rupees 1.7 lakhs. Whether penalty under section 271 subsection 1 clause C is sustainable when the assessment additions were made, but whether there was a concealment or furnishing of inaccurate particulars is in question, and whether the penalty was ex parte and consequential when the quantum appeal partly allowed the deduction. Let's see what tribunal observed and held. The tribunal noted that the CIT appeals held the penalty proceedings were consequential in nature and confirmed the penalty. The tribunal observed that because the assessee didn't participate in the penalty notice proceedings in spite of notice and didn't show concealment of income, since the deduction claim was latter partially allowed, the penalty confirmation stands. So it was against the assessee. Very interesting. Next, Toshiba Water Solution Private Limited versus ACIT Delhi 2025. Relevant assessment year is 2014-15. Date of order 7th May 2025. And relevant section is section 251. Let's understand facts and issue of the case. The assessee filed its return of income for assessment year 14-15, declaring a loss of 10 crore 10.46 crore. The assessing officer completed the assessment under section 143 subsection 3 after various disallowances and determined the loss at 4.7 crore. On appeal, the Commissioner of Income Tax Appeals, CIT appeals, that is deleted most of the additions made by the AO except for rupees 81 lakhs in respect of balances written off. However, the CIT appeals enhanced the income by 1.5 crore on account of provision for contract loss, that is disallowance of contract loss as a new source of income. The assessee challenged the enhancement in the appeal to the tribunal, contending among other grounds that CIT appeals had no jurisdiction under section 251 subsection 2 to enhance income on account of a new source of income. So issues were whether the CIT appeals has a jurisdiction under section 251 subsection 2 of the Income Tax Act to enhance the income by establishing a new source of income in the appellate proceedings, and more specifically whether the enhancement made by CIT appeals on a new source of income is valid or without jurisdiction. Very interesting. Let's see what tribunal observed and held. The tribunal held that the issue concerning contract loss pertains to an absolutely new source of income that is not part of the return income or assessment proceedings, and thus could not be dealt with by the CIT appeals under the enhancement power of section 251 subsection 2. It observed that CIT appeals exercise of power to enhance income on the ground was without jurisdiction, since section 251 subsection 2 doesn't empower enhancement of new sources not part of assessment or order, means it should be for part of the form part of the assessment or order. Consequently, the tribunal deleted the enhancement made by the CIT appeals. The tribunal placed reliance on jurisdictional high court's decisions in Gurinder Mohan Singh Nindra Jog versus CIT regarding enhancement of income on new source beyond appellate jurisdiction. Next, Akshat Education and Charitable Trust versus CIT Ahmedabad 2024. Assessment year not applicable. Date of order 19th August 2025. Relevant section is section 80G. Let's understand facts and issue of the case. The trust, a registered public charitable trust under the Bombay Public Trust Act, engaged in imparting what education, commenced activities in 2014 upon obtaining school opening permission. The trust had claimed exemption under Section 11 and Section 1023C of the Income Tax Act in earlier years, but had never obtained approval under Section 80G subsection 5. The trust was granted provisional approval under Section 80G subsection 5 for the period from 22nd June 2022 to assessment year 2025-26. On 6th February 2024, the trust filed what an application in Form 10AB seeking final approval under Section 80G subsection 5 clause 4 subclause B. The CIT exam rejected the application on the ground that because the trust had already claimed exemption under Section 11 or 10 23C, the application for approval under Section 80G5 was maintainability wise bad. Okay. So issues were whether the application for final approval can be rejected solely on the ground that the trust had previously claimed exemption under Section 11 or 1023C, and whether the amendment made by Finance Act 2024 to Clause 4 of first proviso to Section 80G subsection 5 is clarificatory or retrospective in nature, and thus whether the earlier provision should apply or not. Let's understand what tribunal observed and held. On the delay of 137 days in filing the appeal, the tribunal held that the delay should be condoned since the assessee was what prevented by sufficient cause from filing within the prescribed time. On maintainability of the application under Section 80G, subsection 5, clause 4, subclause B, the tribunal noted that amendment made by the Finance Act 2023, that is effective from 1st October 2023, substituting clause 4 of the first proviso to Section 80G, subsection 5. The CBDT Circular number 1 2024 dated 23rd January 2024 clarified that institutions which have already commenced activities may make an application for regular approval under subclause B of clause 4. The tribunal held that the amendment is remedial and clarificatory in nature and therefore must be read as having retrospective effect. So it held that the legislative intent is to be encourage donations to genuine charitable institutions, and a hyper-technical construction must give way to purposive interpretation. Because the trust had already been granted provisional approval and had fulfilled procedural compliance, the application for final approval could not be denied solely on the ground of earlier exemption claims under Section 11 or 1023C. So accordingly, the tribunal allowed the appeal, quashed the order of CIT exemption, rejecting the application, and restored the matter to the file of CIT exemption for fresh examination on merits. Very interesting, very interesting. Next, Biswas Manik versus ITO Ahmedabad 2025. Relevant assessment year is 2018-19. Date of order 8th August 2025. Relevant section is 17. Let's understand facts and issue of the case. The employer company under a voluntary retirement scheme arranged an annuity policy from what Life Insurance Corporation of India in favor of the retiring employees, including the assessee. The employer paid rupees 20 lakhs directly to the LIC, not to the assessee, for policy allotment in the assessee's name. The annuity payments were structured to commence 4 years later in monthly installments. The assessee didn't receive or have access to the amount relevant to assessment year 18-19. He offered the annuity income when latter received. The AO included 20 lakhs as a perquisite under section 17 subsection 2 clause 5 for the year. So CIT appeal upheld the addition. The assessee appealed to the tribunal. So issues was whether the employer's payment to LIC for annuity contract in favor of the employee can be taxed as a perquisite under section 17 subsection 2 clause 5 in the year of payment, that is AY 18-19, when the employee neither had a vested or immediate right over the amount nor received it in that year. Very important. It had neither a vested or immediate right over the amount nor received it in that year. Let's understand what tribunal observed and held. While section 17 subsection 2 clause 5 covers any sum paid by the employee to effect a contract for an annuity as a perquisite, taxation under section 15 requires that the amount is due, paid, or allowed to the employee. For taxation purpose under section 15, what requires is that the amount is due, paid, or allowed to the employee. A contingent or future entitlement which is not vested cannot be taxed in the earlier year. The entitlement which is not vested cannot be taxed in the earlier year. In the present case, the employee didn't acquire a vested right in AY 18-19. The annuity payments were to commence only after 4 years. Further, the assessee offered the annuity receipts when actually received. Taxing the employer's payment in 18-19 will lead to what? Double taxation. That is once at the employer's payment stage and again when the receivable by the employee, which is impermissible. So the employer's payment to LIC was not made to the employee nor credited to his account, hence it was not an amount paid or allowed to the employee in that year. Accordingly, the tribunal deleted the addition of rupees 20 lakhs in assessment year 1819. Next, Man Energy Solutions India Private Limited versus ITO Ahmedabad 2025. Relevant assessment year is 2012-13. Date of order 11th August 2025. And relevant sections are section 144C and 292B. Let's understand facts and issue of the case. The assessee company was amalgamated into Man Diesel and Turbo India Private Limited with effect from 1st January 2013 under a scheme sanctioned by Bombay High Court on 20th March 2014. The filing of the certificate with the Register of Companies was on 21st May 2015. The AO, despite being informed of the amalgamation, issued the transfer pricing order dated 21st January 2016, a draft assessment order under Section 144C, subsection 1, the DRP direction under Section 144C, subsection 5, and the final assessment order dated 30th January 2017, all in the name of MTIPL, that is the non-existent entity post amalgamation. Very, very interesting. The assessee appealed to the tribunal, contending that the draft and final assessment orders were invalid since they were passed in the name of an entity which didn't exist at the time of the order. So, issues were whether an assessment order and preceding draft assessment plus DRP directions passed in the name of a non-existing entity post amalgamation is valid or not, and whether such defect is a procedural irregularity curable under section 292B or whether it vitiates the assessment completely. Let's see what tribunal observed and held. The tribunal held that once the amalgamation scheme was duly intimated to the AO, and the entity MTIPL had ceased to exist, the foundation of assessment, the draft order being issued in the name of entity that didn't exist was void. That is, we can say void ab initio. It further held that this was not a mere procedural defect that could be cured under section 292B, but a jurisdictional defect going to the root of the proceedings. Since the draft order was void, all subsequent steps under section 144C and the final assessment also stood vitiated. The mere fact that the final assessment may mention the correct name didn't rectify the foundation illegally. Means here foundation is not on a valid part. Accordingly, the tribunal allowed the appeal of the assessee and held that the assessment was void and could not be stand. And now we are moving to our second part of the video, cases reported to High Court. First, Gateway Terminals India Private Limited versus DCIT, assessment year 2012-13, Bombay High Court, date of order 26th August 2025. Relevant section is section 80IA. Let's see what was the issue. Whether interest income earned on fixed deposit kept aside for contractual obligations and interest on refund of TDS wrongly deducted by customers qualify as profits derived from an eligible infrastructure business under section 80IA. Very interesting. Let's see what Bombay High Court observed and held. The Bombay High Court held that the fixed deposits were not mere selfless funds parked idle, but were required under the license agreement to replace cranes and by court order due to a tariff dispute. Hence, the interest had a direct nexus with the eligible infrastructure business and was eligible for deduction under Section 80IA. Likewise, interest on TDS refund was integrally connected with business receipts and thus eligible. Very clearly. Next, Srimati Anvida Bandi versus DCIT, assessment year 2020-21, Telangana High Court, date of order is 22nd August 2025, relevant section is section 96, read with section 144B. Let's see what was the issue. Whether the transactions, purchase and sale of shares by the assessee qualify as an impermissible avoidance arrangement under Chapter 10A, Sections 96 and 144BA of the Income Tax Act, such that tax benefits set off of capital losses can be denied. Let's see what Telangana High Court observed and held. The Telangana High Court held that the tax department failed to do what bring sufficient material showing that the transactions made the statutory test of IAA under Section 96, subsection 1, such as main purpose of obtaining tax benefit, lack of commercial substance, pre-arranged details. Mere timing of purchase and sale of shares on the stock exchange didn't automatically trigger GAR. Accordingly, the GAR invocation was set aside and the order under Section 144BA 6 was quashed. Principal CIT versus Morgan Stanley India Capital Private Limited. Relevant assessment year is 2009-10. Bombay High Court. Date of order 14th August 2025. Relevant section is section 43B. Let's see what was issued. Whether expenses could be disallowed under section 40 subsection E clause 1A and relatedly under section 43B for non-deduction. It is section 40 clause A subclause IA for non-deduction of dues where the pays had already paid tax and the relevant proviso inserted by Finance Act 2013 was invoked. Means whether expenses could be disallowed under that section 40 for non-deduction of dues where the pays had already paid the tax. This pay has already paid the tax and the relevant proviso was invoked. Let's see what was held by Bombay High Court. The Bombay High Court held that the second proviso to section 40 clause A subclause IA, which treats a pay as having deducted and paid tax when the pay files the return, is curative, beneficial in nature, and therefore applies retrospectively from 1st April 2005. Since the pay had already paid the tax, the disallowance under section 40 was not permissible. The appeal of the department was dismissed. So you cannot disallow if pay had complied the tax provisions. So at the end, we will now see one-liner conclusions that can be drawn from today's learning. Let's see one by one. If you want, you can take a screenshot of it. Penalty under Section 271D cannot be levied for genuine cash receipt of agricultural land sale consideration as such transaction falls outside the ambit of Section 269 SS. That is, it is not a capital asset. Short-term capital loss on STT paid transaction can be set off against short-term capital gains on non-STT paid transaction. Section 70 subsection 2 doesn't restrict set off by the tax rate category. Penalty for concealment is sustainable where the assessee fails to substantiate the deductions claim and doesn't respond to penalty proceedings. CIT appeals has no jurisdiction under Section 251 to enhance the assessment by introducing new source of income not considered by the AO. Final appeal under Section 80G cannot be denied merely because the trust earlier claimed exemption under Section 11 or 1023C. Amendment to Section 80G subsection 5 is clarificatory and retrospective. Employer's payment to LIC for annual annuity policy is not taxable as a perquisite until the employer requires a vested right or receives the annuity. Assessment made in the name of non-existent amalgamated entity is void ab initio, as I said, and cannot be cured under Section 292B. Interest income on fixed deposit and TDS refunds linked to the infrastructure operations qualifies for deductions under Section 80IA as it has a direct business nexus. GAR provisions cannot be invoked without concrete evidence of an impermissible avoidance arrangement or lack of commercial substance. The second proviso to Section 40 Clause A subclause IA is retrospective. No disallowance arises when the pay has already paid tax on the relevant income. That's it for today. Please note down my contact numbers. If you have any questions, observations, suggestions, then please do let me know. Hope you are getting valuable knowledge from all these video series. You are getting knowledge and you are going in learning. So stay tuned to the Tax Guru YouTube channel. If you are not yet subscribed, then please do subscribe it for latest updates and video series like this. If you want to share, if you like this video, then remember to click on like and also share in your network to reach to the mass of the people. So stay tuned to the channel, stay tuned to us. We'll meet in next video soon. Bye bye. Take care. Hare Krishna.